Hello landlords, it's Ernie, I'm back, and today we're talking all about the eviction process. What does it look like from start to finish? Let's get started. As always, I am excited to bring you new content, which I do every week. And if you enjoy the kinds of things you see here, give us a like. If you're not yet a subscriber, consider subscribing. But the thing I'm really interested in is what are your thoughts and ideas about today's topic, eviction, or any of the other topics that we cover on this channel. I want to know. So in the comments below, send me a message, ask me a question, let me know what you're thinking. So I'm back, and evictions are still going on. Things have slowed down a little bit, but the eviction train is still moving. I recognize that the CDC eviction moratorium has been rebooted, and while there are currently, requests of the Supreme Court and from other courts around the country that the thing be brought down, I can pretty well guarantee that if there is political will out there to renew it or to reinstate it, it will be reinstated, it will be renewed in a way that's going to pass constitutional muster. And there seems to be a lot of chatter out there that the eviction moratorium is going to persist probably through the end of the calendar year. So I would be ready for that. So if you're going to file an eviction, it's important to know what steps you need to take and the kinds of things you can expect. So number one, because we're cognizant of the fact that this moratorium is here now and potentially here for the next few months, if you do need to remove a tenant, then your best bet is to find a non-rent basis to do that. We talk about that a lot on this channel, that the clearest way to navigate through the moratoria is to find a way to evict your tenant for non-payment of rent. Now, one really good way is simply not to renew your lease. So since last March, I imagine that many leases have come to a natural conclusion. Now, this doesn't mean that the lease doesn't exist anymore just because there's been an end. In fact, your lease may continue month to month on its own. There may be a provision that describes renewal, or you may have done it by operation of simply accepting rent beyond the date of termination, thereby creating an implied month-to-month tenancy. If that's the case, then technically your lease hasn't ended, but it can. So the trick to ending a lease in the state of Texas is generally a 30-day notice of lease termination. This is how you bring everything to a close when a lease has either expired on its own terms, or if you started off on a month-to-month tenancy and you simply want to wrap things up. You do not have to give an answer to the question, why are you doing this? What did I do wrong? Because fault is not required for the termination of a month-to-month tenancy. You simply need to give the requisite notice, and if a tenant asks, we don't recommend that you give definitely not some bogus excuse, because what you really may want to say is, I just don't like you, or I don't want you here anymore, or you don't pay your rent. Unfortunately, those kinds of maybe very honest answers could end up getting you in trouble. And so you're best staying away from it. If your tenant asks you, you simply tell them that you're going in a different direction, or you have other plans for use of your property. And if they ask more than that, just let them know this is a private business decision that you have made. It's as easy as that. So once you've terminated the lease, now I say generally speaking it's 30 days, but your lease may actually require more. Read your lease to find out. Because if you do need more because of what's in your lease, you give more. Otherwise, you haven't generally terminated your lease. But most leases can terminate with 30 days notice. So once the lease has been terminated, if the tenant has stayed beyond the date of termination, then they have committed what is called holdover. And once they've committed holdover, you can send a 3-day notice to vacate and begin the eviction process. So step one is having a cause of action for eviction. In this case, we're recommending that if you have a lease that's either on a month-to-month tenancy or has already expired, send a 30-day notice and establish holdover as your basis for your eviction. Holdover is one of the exclusions of the CDC eviction moratorium order. It's a non-rent violation of the lease. Essentially, that last term, you agree to leave at the end of the lease, and they failed to do that, so they're currently in breach. But it's a non-rent violation that, again, sidesteps the CDC eviction moratorium order. So now you're ready. You've terminated the lease. You've given a notice to vacate. Your notice to vacate has been an unequivocal demand for possession, and you've learned how to count. Right? Remember, this is something we've covered a number of times on this channel. Counting is a little bit different for a notice to vacate because the day you send the notice is actually day 0. It doesn't exist. So don't add it into your calculation. The very next day is 1, and then 2, and then 3. And on the day after, that's when you can file. So, for example, you serve your notice to vacate on Monday. Monday doesn't count. You give them all of Tuesday, Wednesday, and Thursday. Friday then would be the first day you could file your eviction. So remember, if you've given them 3 days, at least 3 full days have to have elapsed. Additionally, did you deliver the notice properly? We've covered a ton of videos. Here's one that you can refer to on how to properly deliver your notice to vacate. So all that's done. You've established a cause of action, preferably one that does not require rent. But, rent is still the best one. It just maybe is going to be difficult during the CDC eviction moratorium period. Again, non-payment of rent is still the best cause of action, but it may not ultimately be the cause of action that wins the day during the CDC eviction moratorium period. And so non-rent, again, can sidestep all of that. Now, so there's an argument then, well, shouldn't I just sue on both bases? And what I found is here in Harris County, that does work for the most part. You can sue as long as you have one non-rent basis to pursue. The courts have allowed those cases to sidestep the CDC eviction moratorium order. In other counties, that may not be the case. And truly, I cannot speak for every judge in every county across the 254 counties in the state of Texas. And so this is the decision you're going to have to make. One other option that you might have that we've talked about is you can sue for possession, for holdover, or some other non-rent lease violation, and then also file a breach of contract claim against the same tenant at the same time and get that rent and late fees and other economic damages rolling in another lawsuit while you push forward on possession in the eviction court. Again, that's one thing you could do. But so we've got our cause of action, we've sent our proper notice, and now we're going to the court to file our petition. Now, I'm going to speak very generally because across the state, there are different fees for the kinds of filing, but generally speaking, it's about $125 to file for one defendant. Now, what's important for you to know is if you've got multiple defendants who have signed the lease, these are the ones who have signed the lease. If multiple tenants have signed the lease, then you've got to add multiple defendants on your petition. If they're still living there, if they have not vacated upon your demand, they're still living there, go ahead and add them to your eviction petition. That's generally going to add another $75 to $80 in filing fees for service of process of the additional tenants. But don't go file just against one because it's a little cheaper, because ultimately you'll be unable to secure a judgment because you're in violation of the Texas Rules of Civil Procedure. If more than one tenant signed a written lease, they all have to be included in the eviction petition. So you file, and now the court has the case in their hands. And the court will essentially assign the case for trial, but they first have to serve notice to each of the defendants named in the petition. Generally speaking, they'll go right to the premises. They'll knock on the door. It's usually one of the county constables. They'll knock on the door and put the notice in their hands. But that may not be the case for all of the defendants, or the defendant may not answer the door or may not be home when the notice is delivered. So eventually the court may have to seek alternative service. This is common, and it might add a week or so to the time frame, but ultimately each defendant must be served in one way. Sometimes they'll mail it, but they're going to try at first to deliver it in hand to the tenant themselves. So the case will then be set for trial, and as long as the tenant had at least 6 days notice prior to the trial should go forward. Now at the trial, you will prove up your cause of action. You prove up your cause of action and establish that you've got a lease, that the lease was breached, and that you gave proper notice, and that you are entitled to possession. Once you establish these facts for the court, the defendant will have an opportunity to present a defense. And so you may say that they're guilty of holdover, and they say, no, I left before holdover began. And if they can prove that, then you can't win. But unless they can prove that, and especially if they're still there, then they certainly cannot win. So let's assume then that you have properly presented your case to the justice court and you have secured a judgment. Thereafter, you will wait out a 5 to 6 day period, allowing the tenant an opportunity to file an appeal. Now, most tenants do not file appeals at this level, but a few do, and so maybe about a quarter of them will file an appeal, and you'll have to go through a few more steps. But we're going to suppose that no appeal was filed, and your judgment becomes final. Once you have a final judgment, then if the tenant remains on the premises, has not filed an appeal, but your judgment is final, you can obtain what's called a writ of possession. Once you've purchased your writ of possession, the judge will sign an authorization for the constables to go out and serve a 24-hour notice to the tenants at the premises. If the constables come back and the tenants are still there after the notice is posted, then the tenants can be forcibly removed and all of their personal property can be removed from the premises. In Harris County, all that stuff is simply put out on the curb and left for trash pickup. Now, different counties do different things and sometimes will warehouse some of this property. Harris County used to do that, but it got way too expensive and it didn't make any sense. And so now they forego that and simply put everything on the curb. So tenants hopefully won't resort to that, but occasionally that does happen. So now you've got a judgment and you've recovered possession, but what about access to your rent? How are you going to get that money back? Well, there are a couple of procedures that you can look into. I'm often asked, well, can't I just send my judgment to a collection agency and aren't they going to go after and get my money? Well, that's the thought, but very rarely does that actually happen. You're better off doing the following two things. The first is obtaining what's called an abstract of judgment. And essentially, if you have the proper information on your tenant, date of birth, driver's license number, social security number, the kinds of things that you probably should have secured during the application process, if you have this bit of information, then you can abstract the judgment and attach these identifiers to the judgment itself, and then file that abstract with the county clerk's records. This is important for a couple of reasons. Number one, if you are unable to connect this judgment to your specific defendant, how are you ever going to attach this to their record? Many landlords are interested in attaching their judgment to the credit history and the rental history of a particular tenant. But if you sued Joe Smith, there's a lot of Joe Smiths out there. And so it's going to be difficult without these identifiers to attach this judgment to the specific Joe Smith who committed this breach. And so if you're looking to collect a money judgment against someone, make sure you have these three identifiers: date of birth, driver's license number, social security number. You add these to the abstract of judgment, and then you file that abstract with the county clerk's office in the county where the tenant resides or works, or both. Now, this will help put that information on the credit history, the rental history of the tenant, and will be your first step in attempting to collect this judgment. Your next step will be to file what's called a writ of execution. So you do this through the same court that issued your final judgment. You'll request a writ of execution. Now, this is important, especially if you know that your tenant has non-exempt personal property. Maybe they own a piece of land somewhere within the state of Texas, preferably within the county where you live, but that's complicated, not always the case. It's more so the case with commercial tenants, but it occasionally happens with residential tenants as well. Maybe they own a boat or they have multiple vehicles. I once represented a gentleman who had a judgment against him, and he had 10 classic cars in a warehouse and had no idea that the judgment that that was awarded, well before I was involved, by the way, but that judgment could be assessed against his vehicles, and those vehicles could be seized by the county and sold at auction to pay off the judgment. We brokered a deal and were able to pay the judgment off without him losing any of his cars, but this is the potential. And so if you know that a tenant has non-exempt assets that can be seized by the county and can be sold at a foreclosure option, that could be another opportunity for you to recover your judgment. Now, that isn't always the case. And so what sometimes happens is you've abstracted your judgment, you've sought to collect it through the execution process, or you've just abstracted it. And some years down the line, because you've attached this judgment lien on the person, whenever that person goes and looks to buy a home or secure credit for a vehicle or some other purchase, you'll find that because of the judgment lien, they are unable to secure these funds. And that's when the phone call comes. And you're contacted about clearing this judgment. How do I get this off of me? And of course, the natural response is, well, you pay for it. And so it may not be immediate, but sometimes a long-term approach to obtaining payment for a judgment is to file that abstract so that if at some point in the future a tenant is securing some kind of financing in order to make a purchase, usually for a house, they'll have to clear this debt with you at that time, and this debt will have grown with interest and still be at the full amount that it was back when you won your judgment. Now, a judgment in Texas goes, you don't have to try very hard, goes 10 years and can be renewed really for the life of the judgment debtor. And so you can renew it again and again and again. However, if you haven't collected it within the first 10 years, it's not very likely you're going to collect it after. But you do have 10 years to collect it, and within that 10 years, it is possible for the tenant to eventually make a purchase like a home that would enable you to collect your judgment at that time. So these are the steps in the eviction process from the very beginning when you're leasing out your property all the way to when you're collecting for a judgment that you've secured in the eviction court. Again, you have a number of paths you can take. These steps and procedures can be complicated, but if you need help, you're going to see my phone number and my email address are here at the bottom of the screen. I recommend that you reach out and ask us a question, shoot me an email if there's something that you're unsure about. If you want to book a consultation, that's also something that you can do at any time. And there are links in the comments below that you can use to get in touch with me or someone from my office. I'm happy to help in any way that I can. As for the future, if you are interested in any additional content, there's a video right here if you are interested in watching more that YouTube seems to think you'll like. If you're interested in subscribing, there's a picture of me right here. Go ahead and click on that to subscribe. But until next time, happy leasing.